Trustees are generally authorized by the terms of the trust or by statute to distribute trust assets, in kind, in cash, or both. When the trust document does not specify a mode of distribution, then it's time to make a reasonable interpretation considered in the light of all the circumstances. This, of course, can be particularly challenging when there are several beneficiaries. Basically, it gets to be a who gets what. Trust document review can be a little like reading medical records. Unless you're familiar with the terms used in the documents or trained in the field, particular provisions can be obtuse, obscure, or really confusing. On the other hand, some trust documents can be very clear. They may have an article or section with a heading such as distribution of income and principal set apart from all of the other headings. And that helps. We can go right to that article or to that section. Trust documents with an article named distribution are also easy to access. It can get a little more complicated when separate sections address distributions of principal and income during the life of the settlor or after the settler's death. It's also important to look for the section that addresses distribution of remainder or residue on termination of trust. Sometimes a trust has a table of contents. This can be very useful. A trust with a table of contents might provide a little greater specificity in titling than a more generic title like distribution. The table might address specific distributions of real and personal, or that's tangible property. It's also likely to cover the residuary or remainder distribution. Whether distributions of trust assets in kind, in cash, is also likely to be addressed. We review a lot of trust documents, usually as a result of some controversy over distribution. We hope that this little explanation helps beneficiaries to identify the section in the trust that describes how assets are to be distributed, or maybe not distributed to them. At Hackard Law, we represent beneficiaries who have been excluded from distribution of trust assets or unfairly treated by fiduciaries. We take substantial cases where we think that we can make a significant difference, and there is a wrongdoer who can be made financially accountable for their wrongdoing or their breach of duty. We focus our geographic reach to California's major urban areas, including Los Angeles, Orange, Santa Clara, San Mateo, Alameda, Contra Costa, and Sacramento counties. If you're a beneficiary and you want to talk to us about your rights, then call us at Hackard Law, 916-313-3030. We'll be happy to hear from you. Thank you.